All right. Are we all in to our partners? Can we all hear each other? Can everybody hear me?
Yes, Eve, we can hear you.
All right. So I think it is 9:05. I would like us to start. By the look of things, we have almost about 100 people in, so we can start with that as the rest of other people are joining us. So good morning, everybody. On behalf of the American Chamber of Commerce, I would like to extend our warm welcome to all our members, our partners, invited guests who have joined us today for this webinar. We appreciate that you've taken time to actually join us today and be able to hear what we have to say. As an organization, AmCham Uganda, we are committed to being the primary platform for fostering strong commercial ties, economic ties, and agricultural ties between Uganda and the United States. Our mission is built on belief that open dialogue, transparency, and collaboration is good for business. So today we are convening this webinar to discuss the draft Protection of Sovereignty Bill 2026. We definitely recognize and respect the government's its main objective to ensure national security and safeguard Ugandan interests. However, as representatives of the private sector, we also have the responsibility to look at these legislative proposals through the lens of business stability, investment climate, and then the practical reality of operating in the global economy. So this is the reason as to why we want to look at this bill. The business community currently is navigating a period of significant economic transformation and then digital innovation, cross-border partnerships. The essential that is regular environment keeps within the pace of the complexity that the businesses are doing. So on that note, we are happy that we are partnering with one of our members, that is TASLAF Advocates. So thank you so much, TASLAF, for coming together and making sure that we are able to pass this information to the members. And why is it important? And why is this discussion is very, very crucial that we should have it. So we've been asked by Parliament to make sure that we are able to submit our concerns as an organization, and as the Chamber and the representative of the business community, we are able to work with our partners who are the experts to be able to provide this information and give recommendations to Parliament. But today we are going to be able to hear from TASLAF, and what are those things that we are going to talk about within the proposal. I will let the TASLAF team to be able to explain how the entire webinar is going to go and what are the things that we need to look out. But we'll ask everybody to hold on to your questions, and you can be able to, if you have any question, you can be able to put it in the chat, or you wait until we have gone through the entire presentation of the presentation, and then you can be able to give your questions, and you can raise your hand, and we shall be able to answer you and give you all the, and with the experts we have on the group will be able to give you all the answers you're looking for. So thank you so much. We are grateful that you've taken your time, and welcome to the AmCham and TASLAF Protection of Sovereignty Bill 2025. So I would like to welcome the representatives from TASLAF to give, I think, Steve, you give your opening remarks, and then we can be able to go through into the presentation.
Thank you, Eve, and good morning, everybody on the call. My name is Stephen Tumwesji. I'm the managing partner of TASLAF Advocates. We are members of the American Chamber of Commerce, and we are tasked this morning to go through the Protection of Sovereignty Bill 2026. What we're hoping to do in this process is perhaps 3 or 4 things. Number one, we hope to go through what the law provides for as it is now, the Protection of Sovereignty Bill 2026. What are the key clauses that it provides for? We will then go through what we think are constitutional and other legal concerns. I mean, there are many people who have raised these concerns, the Uganda Law Society, the Bankers Association, and other chambers who have noted the constitutional and legal concerns. And I'm sure you've seen, for those who are in Uganda, the debate around the law on both TV and radio. We also then cover aspects of noting how the law, if passed in its current form, is going to affect businesses, is going to affect organizations, and how, if it's passed in its current form, will affect the general economy as a whole. We have come up with recommendations of how we think the law should be better structured or in a way rethought because of the concerns that we raise above, the constitutional concerns. And then we will provide next steps in terms of how to engage with Parliament, with the committees that I have invited for comments. So that will be the structure. I'll be making this presentation with my colleagues, Remy Wahanze, who is on the call. Remy, if you can say hello. You're on mute.
Good morning. Good morning, ladies and gentlemen. It's a pleasure to be here. My name is Remy Wahanze. I'm an associate at the firm and looking forward to a great deliberation.
Yeah. And my colleague, Ruth Nanjobe, if you can also introduce yourself.
Okay. Yes, good morning, ladies and gentlemen. My name is Ruth Nanjobe. I'm a senior associate with TASLAF Advocates, working with our Legal and Regulatory Compliance Department, and we look forward to having a fruitful engagement with you this morning. Thank you.
Thank you both. So I think we can go through the structure of the presentation. We are going to cover, first of all, what is in the bill. So where did the law come from and why the interest in the protection of sovereignty for Uganda. We will note that it came through an NRM Parliamentary Caucus endorsement. We'll look at the current legislative status and where it is, and to stem any anxieties in the room regarding whether the law has passed already, we'll go through Uganda's lawmaking process and whether not where the law is at the moment. We'll then cover the three critical definitions, and we'll be noting them on who is a foreigner, who is a foreign agent, and then what is prejudicial to the state. Okay. We then note the legal and policy concerns that we have, some of them indicating that the law is in conflict with our constitution as provided for, the 1995 Constitution of Uganda. We'll note that some of the provisions that the law seems to cover are already covered under different laws. We'll note the conflict with data privacy, public finance management, and other anti-money laundering provisions. And then we'll cover what we think are concerning the penalties and the compliance regime of the law. Obviously, I mean, the debate has also gone around noting that there's been other countries that have come up with this law. So we'll look at the comparison of how the UK, the US, and Australia are covering their sovereignty, or the equivalent of their sovereignty bill, and how they protect their sovereignty. We'll note the international obligations that Uganda has signed up to, including the African Charter, ESC treaties, and other bilateral investment treaties, and how they affect, how the law would affect those treaties. And then look at the implications for you and the business if the law is passed in its current form, and the way forward in terms of substantive legislative recommendations and how to monitor the bill as it goes through the parliamentary process. Yeah, so Remy, next slide. Remy, if you can move the next slide, please.
Yes, is it moving? I have already met the... Yeah.
Now, the previous one, the previous... Yeah, so what is in the bill, the origins and status of the bill, okay? As you may have noted, the law entered into the public circulation through what we would call a very fast process that we saw through the bill's text appearing on public platforms and creating a bit of pandemonium around what its intention was. And then on 28th March, we saw the NRM Parliamentary Caucus supporting the bill's passage at State House with the parliamentary spokesperson announcing the endorsement and framing the bill as operationalizing Article 1.1 of the Constitution. So the initial draft of the bill was in public circulation, but not through a formal process. But now what we have is that the bill has been published in the Gazette on 13th April 2026 as Bill number 13. And the bill has 30 clauses across 5 parts. On 15th April, the bill was formally tabled in Parliament for the first reading and now has been passed to the committee stage for management. I think there was a circulating document indicating that the law had gone for second and third reading, but we verified and noted that the law has not gone through that process. Yeah, so as we noted, the not to cause anxiety and fear in the population, I think as of now, the law has not yet passed through the parliamentary law-making stages, but indeed the law was formally introduced to the relevant sessional committee. Now it's at the committee stage, so the committee examines it clause by clause, invites expert evidence, and also invites written submissions from different people who are concerned about the law. So I think the deadline is on the 24th, Remy, if I'm not mistaken, to submit all these concerns that people might have. So please ensure that you submit your concerns around the law in this period, because that's when you have the opportunity to make any recommendations. There are people who are already doing this. The Ugandan Law Society is submitting its submissions on this law. I think the FITSPA, which is the association that brings together all the financial sector players, plus the Uganda Bankers Association, who have written the Attorney General regarding this. So it's still an opportunity for the other chambers. I know that the British Chamber of Commerce, the NUTIP, and the AmCham are interested, so it would be useful to use this stage. And once the committee stage is passed, the bill goes into second reading and third reading. And if it gets its vote in Parliament on the third reading, it is passed into law. But in Uganda, the law still requires the presidential assent. So the president has 30 days to assent to the law, return the law for consideration, or refuse to sign the law. But once he has signed, then the law is published in the Gazette, and the obligations take form. So we thought we'd cover that area of how the law is passed in Uganda to guide and not create fear that the law has already been passed. So the law is still in Parliament, and there's potential for it to be changed or to make recommendations for its changing. Yeah. So let's go to the main thrust of what the law covers. And I'm sure everybody has been hearing about what the law is, but let's go into the key definitions and principal provisions, and we'll tell you why some of the provisions are very concerning. So I think let's begin with the definitions of the law, but also before even the definition, just what the law is, the object of the bill. So the object of the bill, when you read clause 1 of the bill, is intended to provide for the protection of the sovereignty of the people of Uganda. That's number 1. Designate a department responsible for peace and security as responsible for the registration and regulation of agents and foreigners. So there's a department that is going to be regulating and registering agents of foreigners. And then 3, to provide for the sovereignty of Uganda provide for the registration of agents and foreigners, and to regulate the funding and other assistance to agents of foreigners and for related matters. So you can clearly see that around it, there's three things that come out. Number one, who is the foreigner? Who is the agent of a foreigner? And what is the law calling disruptive activities? Okay. So I'm sure you've seen the concerns that have been raised. Number one, that it includes, the definition of a foreigner includes non-Ugandan citizens, obviously. But concerning there, it also includes Ugandan citizens residing outside of Uganda. It includes foreign governments, embassies, consulates, any company or NGO incorporated or registered outside of Uganda. So if you think of a subsidiary of another company, it's also considered to be a foreign agent, a foreigner. International and multinational organizations. And third, and the last one, any entity the minister may declare a foreigner by statutory instrument at any time without parliamentary approval. So again, the definition obviously is concerning because at any one point, a minister may declare one a foreigner by statutory instrument. But also the other concerning thing is Ugandan citizens residing out of Uganda are considered to be non-citizens for purposes of this law. So we'll show you how this is concerning for the public, but also in regard to citizenship as a whole for Ugandan citizens. Now, the law then goes further to define an agent of a foreigner to mean anyone who acts as an agent, a representative, an employee, or servant of a foreigner. Okay, so that's a very broad definition. And then it also notes that anyone whose activities are directly or indirectly supervised, controlled, financed, or subsidized by a foreigner. Again, that becomes an agent of a foreigner. Okay, now the third definition, which is key, is what is defined as disruptive activities, that you have to engage in disruptive activities. If you engage in disruptive activities prejudicial to the interests of Uganda and you're a foreigner, then you are going to be sanctioned under this law. So disruptive activities are defined to include acts prejudicial to Uganda's security, employing or contracting persons to promote foreign interests, participating in demonstrations, disruptive or interfering with any person's lawful activities, business operations, or human rights. Okay. Now, we note that all these definitions under the law are what we call broad and subjective. So they could be given any interpretation at any one point. Now, when you're drafting the law, it is a requirement under both the Constitution and the Acts of Parliament that you make sure that whatever you're defining is clear and therefore not subject to broad and subjective interpretations. And we'll see and note how this can be abused in the process as we go along in this division. So key to note, the definition of the foreigner, the agent of a foreigner, and then what is described as disruptive activities under the law. Yeah, you can move ahead, Remy. Yeah, so then there are certain clauses that we have noted within the law that we think are very, very concerning, and people should take note of them. The first one is under clause 5, which says, no person shall engage in any activity that promotes the interest of a foreigner against the interests of Uganda. So again, what we mentioned that the law is broad and subjective is that the interest against the interest of Uganda is not defined anywhere in the bill. As I'm sure most people would know, for you to commit a criminal offense in Ugandan law anywhere in the world, you need what is called intent. So you must have demonstrated that you're doing something against the interest of Uganda for a particular reason. Okay. So the law then punishes you even before you you have proved any intent. So accidental or inadvertent conduct is captured. It applies to individuals of any kind. And then finally, the penalty. So the penalty for promoting the interest of the foreigner against the interests of Uganda is up to 20 years or Uganda shillings 2 billion and Uganda shillings 4 billion as a penalty. So this is really an excessive, we think excessive penalty for this kind of offense, which is also not defined properly within the law. So I think this clause should be studied further to demonstrate, number one, intent, but also require DPP's consent before it is, before one is prosecuted under the law. And then we note under clause 13, which is within the law provides that any person who publishes information or participates in any activity that weakens or damages Uganda's economic system by causing disruption, insecurity, or instability commits an offense. Again, we go back to the definition, broad and subjective. There's no definition of activity that weakens or damages Uganda's economic system. So we think that's going to be subject to abuse and therefore may require a proper definition in that regard. So if you think of a researcher publishing poverty data or an economic analysis that doesn't bode well for what is provided for within the government policy, that might be a problem. So a journalist publishing or reporting on public finance or accountability is also sanctioned under that clause. If you're an academic writing on Uganda's economic policy or performance, potentially you could be affected under this clause. I mean, if you're a donor and you have published honest assessments of program challenges, this clause might be against you because it might be interpreted to mean that you are creating economic sabotage for Uganda. Again, the penalties are the same. And the penalty of up to 20 years, you got shillings 2 billion to 4 billion for participating in what is called economic sabotage under this sphere. I think let's move ahead on the registration regime and cabinet approval. So there's a problematic clause 6, which talks about I think, Remy, you're moving ahead of me. Clause 6. So it says that agents of foreigners may not provide services in sectors for which government is responsible. So the law seems to suggest that there are certain sectors for which government is only required to participate. And they highlight some of them: health, education, water, infrastructure. And it requires that before a foreigner or an agent of a foreigner participates in such activities, they would need cabinet approval. So a WASH program, a public infrastructure program that is not funded by, that is not approved by cabinet, there's a requirement that if you're going to participate in such work, you're required to register with the cabinet. So you have to get cabinet approval. So most of the development work would be affected, especially for the non-profit sector, for development partners, and other embassies. So it's a very concerning clause. Clause 7 talks about that agents of foreigners may not develop, influence, or propose amendments to government policy without cabinet approval. So again, we go back to the other clause, which in a way seems to suggest that no one should be able to influence cabinet policy or government policy without cabinet approval. Clause 8, again, agents may not implement government policy without cabinet approval, and approval should be backed by written undertaking. Okay, so it prohibits, in a way, the law seeks to prohibit the participation of agents of foreigners in influencing government policy or working on activities where the government is largely responsible. Now, the other Concerning clauses are 14 to 20, which requires that all agents of foreigners must register with the Department of Internal Affairs before operating. So the Department of Peace and Security, which is designated as the department responsible, is supposed to register all foreigners. And if you don't register, then there's a penalty of imprisonment for 10 years or a fine of 1 billion shillings. The other concerning bit around there is that clause 15 requires you to include all your employee details, all the foreigners you act for, copies of all agreements, and a notification of all the 60 days financial contributions, and all political activities, if any. So again, registration regime, so you're subjecting the registration of all persons who are purportedly agents of foreigners to the department within the ministry, which we think will not be able to do the work of registering all foreigners, or their agents anyway. And then clause 16 also gives powers to the department to inquire into the mental and physical health of applicants, and notes that certificates are valid for 2 years only. So the department may inquire into the mental health and physical health of the applicants. We do not know how this is going to operate in real life, because I don't know whether the department is going to put up psychiatric wards and etc., but that remains to be seen how it's going to be implemented. We also note that under clause 15, there are concerns around data privacy and protection, because all this data that you're picking up, you don't know how it's going to be stored. And then clause 20 clothes the Minister of Internal Affairs with too much power, noting that the minister may revoke a certificate at any time without prior notice and without the opportunity of the holder to respond. Again, there are many constitutional concerns around that the minister may wake up and revoke, even when you have registered a certificate at any time. Again, it doesn't subject it to a fair hearing under our constitution, and my colleague Remy will be covering the constitutional concerns of the same. I think let's go to the funding controls. So again, agent of a foreigner, agent of a foreigner participating in subversive activities, the registration regime requiring you to register as an agent of a foreigner, and then now finally the provisions around funding controls and banking obligations. Now, the Uganda Bankers Association has written a very good detailed paper on how this law is going to affect the banking operations and processing of payments. But let's look at how the law provides for, what the bill provides for under funding controls. So the law requires agents of foreigners to declare sources of funding to the minister, okay? And number two, that the declarations of foreign funding will be publicly available for inspection on the payment of a fee, okay? So again, this information has to be disclosed if you're an agent of a foreigner, and the information can be accessed by anybody. So we think that there are concerns around privacy, around disclosure of information, which is in conflict with the data protection provisions within Ugandan law. Now, clause 22 notes that any receipt of foreign financial support exceeding Uganda shillings 400 million in any 12-month period requires the minister's written approval in advance. So if you're an agent of a foreigner registered, and then you're receiving financial support exceeding 400 million, approximately USD 100,000 in any 12-month period in 1 year, then you require the minister's written approval. So you can imagine the burdensome requirements if you are participating in any business that is capital intensive, or you are participating in, if you're a non-profit and you're doing program activities. So all this has an effect on many, many organizations, and Ruth will be covering that in detail. Now, there's criminalized funding. If you receive funds from any foreign entity which has demonstrated intention to overthrow government or endanger Uganda's security, and the penalty for that is 20 years in imprisonment. Now, again, we go back to the definitions, why we think the law is vague and subjective. The intention to overthrow government has not been defined within the law, and so it's subject to varying interpretations, which we think are concerning. And then if you're going to fund government and you're a development agency, you are a sovereign fund, all foreign funding to government institutions are now treated as public funds and are subject to the Public Finance Management Act and require the approval of the Minister of Internal Affairs in addition to the Minister of Finance. So if you're going to participate in funding to the government of Uganda, under the law, you're now required also to get approval from the Minister of Internal Affairs in addition to the Minister of Finance, who has been approving funding to government. So again, I think that's something that even government might need to consider and see whether it works in regard to how you attract foreign funding in the country. And then now the final one is in clause 25, which imposes an obligation on banks, which under the law, it is defined as supervised institution, that all banks must obtain declaration and authorization before paying agents of foreigners. And again, make monthly reports to the minister of the amounts received by agents of foreigners in Uganda. Now, this is a clause that has been highlighted by the Uganda Bankers Association as being very irrational in terms of how processing of payments is done in Uganda and other places, and how it will affect the provisions of banking within Uganda. Yeah, so those are the key clauses we have been able to look out for that we think are very concerning. But the overall object of the law is to protect the sovereignty of the people of Uganda, designate the department as the one responsible for peace and security, as the one responsible for the registration. So then there's the registration of agents of foreigners, and provide for the registration of agents of foreigners in that regard, and also the funding constraints around how you secure funding. So I would like to invite in my colleague Remy at this stage to take us through how we think these provisions are concerning in terms of one, our constitutional and legal framework, but also other laws that are already existing and how they conflict with this law. Yeah, and hopefully it will be able then to answer some of the questions that I see are popping up in the chat room. Thank you very much.
Yeah, thank you very much, Stephen. Yes, so essentially of course, but basing on the background of what the law provides for, we have observed a couple of legal and policy concerns. And these relate to a lot of, a plethora of laws, Ugandan laws, including constitutional conflicts, laws regarding existing acts of parliament. And yeah, so I think for constitutional conflicts, what we see is, yes, what we see is really the objective 26. I think this is exactly why, in terms of the foreigners, which are sort of like set out as per the definitions clause of the provisions of the bill, is regarding objective 23 talks about there's a direct conflict there, because under objective 23 of the state objectives and under the constitution, it provides for NGO independence. Of course, what we see here is that the bill wants to make sure that it checks a couple of activities by NGOs. That is one of the conflicts we see. But we also see something regarding fair hearing, Article 44, Article 44 regarding fair hearing, and specifically because Clause 20 gives permission to the minister to revoke a certificate without notice or hearing. So it's clear that it's a direct violation of a right constitution, of that right, of the right of fair hearing set out under the Constitution, and sometimes becomes extremely onerous. We also looked at Article 29, freedom of expression, and that's specifically with respect to Clause 13, I think, which sort of like sets out the offense of economic sabotage. I think this has been litigated numerous times before our courts. I think in Charles Onyango Bo and Andrew Moinda and a couple. But we see clearly that this law is going to find it difficult to withhold the test set out under Article 43 on proportionality of something that is demonstrably justifiable in a free and fair society. We are also looking at protection of property, specifically Article 26 of our Constitution, and that's with respect to compulsory deprivation. Clauses 22 and 23 of the law provide for forfeiture of funds with no compensation mechanism and no rights to prior challenge. So that essentially means that in the event that you're found in violation of this law, you are most likely to forfeit the funds that you have received. Say you received 1 billion shillings for your operations. So that's one of the provisions in terms of protection of property. Article 27 on privacy of persons. Unfortunately, the provisions regarding the inspection of the mental, financial, and physical, kind of health, and the unannounced inspections under Clause 28, those in themselves even actually undo the provisions of the NGO Act, which sort of like set out the 3-day notice period. And I think, of course, as I've stated regarding the proportionality, under Article 43, for limitation of rights that are demonstrably justifiable, there are a couple of things that need to be plugged. With respect to its coincidence with existing law, I think really we are of the view that a couple of the things that this law is trying to legislate for have already been legislated for under a plethora of laws, including the Penal Code Act, the Anti-Terrorism Act, and the Anti-Terrorism Regulations of 2023. A case in point is Section 36 of the Penal Code Act, which provides for publication of military information, which is prejudicial to security. That's an offense, right? And the Terrorism Act also provides for terrorism financing, funding of terrorist acts. So do the regulations, which declare terrorist organizations and individuals. But what we see in the law, it sets out things like promoting foreign interests, economic sabotage, receiving funds for disruptive activities, and this is still within the definition of terrorism. The other aspect is on intent. I think it's a very, and maybe the legal people who are here, I think when a crime is committed, there's a request, there must be intent, yeah? For, there are two elements, the mind and the action itself. So what we see in this law is that it creates a strict liability requirement under clauses 5 and 3, that the moment you are found doing an action that has been sort of like talked or that has been made unlawful within this particular law, then you have no recourse to defense, and as such, you commit an offense. It's like running a red light. When you run a red light, there's no explanation as to how and why you ran the red light. You simply ran the red light. So that's an issue that we are seeing. But I mean, if you look at the Penal Code Act, the Anti-Terrorism Act, and the regulations, all of those provide for intent. We also noted that the DPP, with respect to consent, all of these laws, including the Penal Code, the Anti-Terrorism Act, and the regulations, provide for DPP consent in order for that prosecution to proceed. under this law, we are seeing none. And regarding court oversight, there are a couple of things, of course, under the Penal Code Act, the Standard Criminal Courts, and the High Court, which really is supposed to handle terrorism offenses. And we also see that in this particular bill, it's ministerial decision. So there's no judicial order to forfeit. So if you're told to forfeit something, there's no need for a judicial order to be made by court. And for the most part, that is, of course, an implication on some of maybe the investors and people who come to play or do work in this market, because then there's no recourse. We are seeing aspects of there not being independent oversight, and I think that's really the balance of power between the state and and what we see is that here there's no check regarding, so it's all vested in the powers of the minister, but also the Department of Peace and Security under the Internal Affairs Ministry. In all these other laws, we see that there are a bit of checks, including the DPP and High Court, the IGP, the Financial Intelligence Authority, and the DPP. And then I think the biggest elephant in the room is the penalty, which we find to be almost 2 times what is prescribed, actually about 2.5 times what is prescribed in the previous laws, because under the Penal Code Act, most of these offenses are in the range of 7 years. What we see even under the Anti-Terrorism Act, 10 years. What we see in the bill, it provides for 20 years imprisonment or 2 to 4 billion, or both, depending on the determination of the body. So beyond, of course, the draft that was published much earlier, as Stephen had stated, there are a couple of offenses, new offenses, including promoting foreign policy, that's under Clause 10, electoral interference, that's under Clause 11, interfering with government operations, that's under Clause 12. And all of these still carry the same sentence, which is 20 years or 4 billion for a company and 2 billion for an individual. So in terms of the other concerns, and specifically data privacy, the Public Finance Management Act and the Anti-Money Laundering Act, we'll look at the conflict under Section 9, which really provides for spatial data that may not, that should be collected without explicit, that cannot be collected without explicit consent. And specifically, Clause 21(2) makes financial declarations available to any member of the public. So that in itself is problematic, given that it's going to be, your financials are going to be open to the public for inspection in the event that you're seeking a declaration in that regard. And yet, under the Data Protection and Privacy Act, that is an offense. So Section 35 of the Act provides for it as an offense, and actually takes a sentence of 10 years and also 2% of the gross annual turnover. So the bottom line is the implementing ministry could, there could be difficulties and conflicts in the law regarding that. The other aspect we've observed is the Public Finance Management Act, which really designates the Minister of Finance as authority receiving monetary grants to government. Of course, with parliamentary appropriation and Auditor General oversight. So Clause 24 sets the Minister of Internal Affairs as a parallel approval authority. So that creates 2 approval authorities in that regard. And as a result, that means that if there's an international development organization that is doing that kind of work, and of course, there's supposed to be a monetary grant that's being given, the approval process must also include the Ministry of Internal Affairs. So every funded, government program currently in Uganda is supposed to face dual ministerial exposure and before its commencement. Anti-money laundering, which is the AMLA, of course, that requires the banks to of course report with the FIA, and I think that's a continuing obligation even for professionals like lawyers And Section 9 talks about confidentiality. In this particular clause, we see clause 25 in this particular bill sets out that banks must submit monthly reports on the same transactions to the Minister of Internal Affairs. That in itself seems to be a conflict in our understanding. So the same information is simultaneously confidential under the Anti-Money Laundering Act is publicly disclosable under this bill. So banks, of course, they have an overbearing regulatory burden, and I think that has been laboriously explained in the letter by the Uganda Bankers Association to the Attorney General, and I think hopefully there will be some movement in terms of changes. So with respect to penalties, of course, I think there are 8 things that you need to look at. What the bills adds on top of existing obligation, which is security sector registration under the Internal Affairs. Ministerial funding approval for every grant exceeding 400 million. So if your budget is beyond 400 million and you probably need that money to run operations over a month, you might have to keep seeking approval. Banking pre-authorization before each fund transfer is released. Monthly bank reports to the Minister of Internal Affairs. Periodic financial returns to the Minister on all funds received and spent. Cabinet approval for service delivery in health, education, water, and infrastructure. Cabinet approval for policy advisory, and I think that's something we have highlighted, and inspections that are, of course, in their nature are unknown. So I think, yes, I will hand over to my colleague who will discuss remittances. Oh, yeah. So with respect to, yes, hello, Stephen.
Yes, Rami.
Remy, we can hear you.
Okay, perfect. With respect to remittances, and I think it's a question that has been discussed at length under under social media platforms and the like, about how do I, in terms of, and not to actually ruffle a lot of feathers, how do you're sending money. I mean, the law has already categorized a Ghana living abroad as a foreigner. So the bill provides that they may qualify because there's a threshold, financial threshold. So if that threshold is reached, then you may qualify to seek that approval from the minister. So that in itself has no exemption for family members, and I think maybe that's something that needs to be looked into at this second stage of legislation. In terms of the banking trap, what we see is that and I think as explained by the Bankers Association, it's going to be very difficult in terms of regulatory compliance because there's a 4 billion penalty. In terms of payment, of course, the customer is claiming on this end, and on the other end, there's a penalty they have. The Minister of Internal Affairs is asking them to report, right? And so, because there's a conflict in terms of timing, the bankers are likely to, default or to fail to fulfill their contractual obligations under both their obligation to the state and the obligations to the clients. And I mean, the principal obligation in that respect for a banking relationship is usually the fiduciary duty between themselves and the client. The state comes in as a compliance and regulatory requirement. So that in itself is a problem. We looked at the Investment Code Act really for foreign investors who come into this market, and specifically regarding the ICSID arbitration process. Of course, registered investors against compulsory acquisition are protected without compensation. So the Act requires secondary permits to be processed within 14 days. That's the Investment Code Act. But the bill in itself is open-ended. And so we see a bit of conflict there. And we think that investors should assess any other protections under the treaty, and specifically the ICSID arbitration process. Yes. So I think the other aspect that we will discuss is the international picture, which is really a comparison between this law and other laws. And I'll hand over to my colleague immediately after this. And specifically looking at the UK Foreign Influence Registration Service Registration Scheme, That's an act of the UK law that sort of like is similar to this law. We looked at the US Foreign Agents Registration Act and the Australia Foreign Influence Transparency Scheme. And if you look at all of those, the scope and is a bit broad and as I'd highlighted. There are a couple of things there that are not including the max custodial sentence, whether intent is required, and the exemptions for specific groups like humanitarian, academic, and commercial. I'll also look at there are a couple of other conflicts with the international legislations, including the ICCPR, which is the International Covenant on Civil and Political Rights, freedom of expression. As we have explained, really, under our constitution, there are a couple of things, and the ESC treaties and our obligation to the international community. I will now hand over to my colleague Ruth, who will then take us through the aspects of implications. And yes, Ruth, are you there?
Yes. Yes, thank you.
Yeah.
Thank you, Remy. Yes. Yes. So moving to what this bill means for us and various sectors. Obviously, some of the implications have already been highlighted in the course of the presentation. So really, this will just be to reiterate them. So here we had sort of so with respect to international NGOs, these are some of the implications, but these are also really applicable to entities in other sectors as well. Firstly, for any, so let's say an entity, whether a local NGO or any kind of entity that is receiving foreign funding, we see that pursuant to clause 22 of this bill, there is a requirement for ministerial approval before receiving any grant that exceeds 400 million. And the provision goes ahead to provide that any unapproved funds will thereafter be forfeited. So that's one thing definitely that this law, this bill, if it passes into law, would necessitate. So for receipt of any kind of foreign funding, that restriction applies, and as such, any approval beyond that threshold has to be sought. Then when you look at clauses 6 to 8 of the bill, we see that there is a requirement for cabinet approval required for all health, education, water, and infrastructure programming. So obviously, none such activities can be carried out without obtaining cabinet approval. So that's also something for any players in this sector to take note of. Of course, in light of the penalties that accrue if such approval is not obtained. Then when we look at clause 20 of this bill, it does provide for, so as had earlier been mentioned, as an agent of a foreigner, if you fall within that category, you would have to obtain a certificate of registration from the ministry. And it's important for us to note that there is, the minister has the power to revoke this certificate if they deem fit. So to suspend it or revoke it. And there are various grounds that the bill provides that could potentially serve as grounds for the revocation of this certificate of registration, such as if you give false or misleading information at the point of registration, if you're no longer considered a fit and proper person to hold this certificate of registration, or if you're various instances. However, those specific provisions do not negate the generality of the initial provision, which actually gives the minister the power to revoke this certificate of registration. So that's also something important to note. And as earlier been highlighted, the certificate of registration is valid for 2 years and has to be renewed 3 months prior to its expiry. So as an agent of a foreigner, that's something that you would have to take note of. Then when we look at clause 13 of the bill, it provides for program reports, research publications, and donor assessments. with respect to risk economic sabotage prosecution. So that's also something to take note of. Then, as had earlier been highlighted by my colleague, Remy, Clause 25, which requires bank pre-authorization before each transfer, monthly reports to the Minister of Internal Affairs. And then when we look at Clause 15 to 16 of the bill, this requires for disclosure of employee health data and 60 days financial records without the DPPA consent. So really, like has already been highlighted in the course of this presentation, the compliance burden is heavy, the reporting burden is heavy, the requirement to obtain approvals for various aspects is there. And it's also important for us to take note that if this bill actually passes and becomes law, there are penalties that accrue for failure to adhere to these various compliance obligations that have been set out. So we had extracted some of the immediate actions that we would think would be necessary for NGOs if, or really persons in these various sectors that are affected. And one, it would be important to map all grants and budgets against the 400 million annual threshold immediately. Like we had highlighted in section 21, which requires a declaration of, clause 22 requires approval before receiving any grant that exceeds 400 million Ugandan shillings. So it may be necessary to, revisit and weigh, the amount of funding that you're receiving or grants that are being received against this threshold, which would then require you to receive approval. Then it will also be important to audit all local partners, sub-grantees, and consultant relationships for an agent of foreigner exposure, right? Then it would also be important to review all publication and advocacy outputs against the economic sabotage provisions in Clause 13 to ensure that you're not in contravention with them. Then, of course, brief your banking partners on Clause 25 before Clause 25, which provides for the reporting of foreign funding. So it's important to brief your banking partners before you commence, any transfers so that there are no cash flow disruptions. Then specifically for the NGOs, it would be good to engage the NGO Bureau as an institutional ally on its registration mandate. Then right now, really, as we had noted that this bill is still at the committee stage, we encourage us to really prepare written submissions for the committee as the bill is being, so that, your thoughts and, your thoughts and sentiments and how this bill could potentially affect you are received. And it's also important to coordinate with civil society umbrella bodies and forums to, have a unified position as we are making these submissions to the committee. And so these are some of just the some of the immediate actions that we could take in this at this point. Then if we look at some of the implications for development agencies, I really won't go deeply into this as they have already been highlighted, but we had already made mention of the Public Finance Management Act. And we see that Clause 24 of this bill introduces the Minister of Internal Affairs as a parallel approval authority alongside the Minister of Finance. So there is that, aspect to take note of. Then the cabinet approval of technical assistance, clauses 7 and 8 of this bill, subject technical assistance to government ministries and policy advisory activities, core development functions, and they all subject this to cabinet approval. And then we also see there is an aspect of dual reporting and the conflict that exists with the Anti-Money Laundering Act. So really to just summarize these implications, which have sort of come through, it's important to note that if this bill passes is passed and becomes an act, the compliance burden is huge. The penalties that accrue from non-compliance are also heavy. So it's important to be aware of where, depending on which sector you fall in, where you would potentially qualify as an agent of a foreigner, or if you're engaging in any activities that would constitute activities that fall within the government policy activities, to ensure that you obtain approval for the same, for the thresholds of funding that is coming in. If you exceed that threshold, it's necessary to obtain the necessary approval for the same. So I think really the other implications have sort of come through, and we're happy to discuss any from any questions that may arise. But I think I can now would now be moving to our last section, which is the way forward. So really, what next in terms of the discussion that we've had? And I'll hand over to our managing partner to take on this part. Thank you.
Thank you, Ruth. And for those joining us at this stage, we have covered maybe 3 or 4 aspects of the law. We covered the law as it is. We covered the constitution and other legal concerns, which Remy perfectly highlighted. Ruth has been covering how the law, if passed in its current form, is going to affect organizations, businesses, development partners, etc. And now we want to highlight what we think should be, what recommendations we think should be in the law. Obviously, if there are any members of parliament listening or policymakers, our initial consideration is to think that there are many provisions within the laws of Uganda that provide for the protection of sovereignty, and other laws that really can regulate conduct that is thought of to be prejudicial to the Ugandan state. And so our recommendation would be to rethink the law and rethink it in terms of how it would work in line with other laws. And if you find that then the laws already provide for this protection, rather than waste taxpayers' resources, shelve it and use the law as provided for already. But if that fails, we have made some recommendations to the legislative recommendations. Number 1, we think that the definitions of the definitions within the law should be refined and stop being broad and subjective. As we've noted above, the definition of the agent of a foreigner, the definition of disruptive activities, interests of Uganda should be precisely defined and put to specific conduct, because it poses a genuine risk of being given varied interpretations, which can then lead to abuse. So we think that those definitions should be refined. We also think that the law should restore DPP consent before prosecution, as it is with other laws, including the Penal Code, the Anti-Terrorism Act, and others. We also think that the law should be integrated with other laws, as we've noted above. There are many laws that guide this kind of conduct, including the NGO process. Every foreigner who is in Uganda perhaps has an immigration notification. So how do you integrate that process with the NGO Act, immigration, and other laws? We've noted above that the law now requires the Minister of Internal Affairs to approve foreign funding even for government institutions, which we think is in conflict with the Public Finance Management Act. And so we think that it should be refined rather than have 2 ministers approving, which we think might create a conflict. We've made recommendations around how the protection of banks can be done. And we think that there's already a protection under the Bank of Uganda as a coordinating banking authority. And so banks should not be subjected to the Ministry of Internal Affairs for that purpose. Again, more broadly around the protection of investors. So Uganda has been obviously trying to attract investors, make way for, promoting Uganda as an investment decision. And so we think that the law as currently structured is going to affect that process. And so investor protections already provided for under our different investment laws should be considered before the passage of this law. Again, we note that procedure standards are not provided for under the law. The law gives out of power to the minister to do all sorts of things. So we think there should be restored procedure safeguards in regard to appeals. When do you remove someone or register them as a foreigner, etc. Again, we've noted the penalty structure, which is a huge penalty structure. Uganda shillings 40 billion, 20 years of administrative failures. We think that should be rethought. Again, the law should think of the privacy concerns we've raised earlier. Any data collection, data subject notification should all be subject to the data protection laws in Uganda. Again, the point my colleague Remy made around personal remittances, which I think has been discussed in the media, regarding people who are sending money to their relatives in Uganda and they are foreigners. I think there's someone who asked the question around people who are paying school fees, but it's being remitted through the international system, and therefore would be under this law categorized as foreign nationals. We think that they should exempt personal remittances before this affects the economy as a whole. So in that regard. And finally, of course, transitional provisions. The law creates penalties when the date is passed. So we think that there should be a transitional provision if the law is to be passed, providing for lawful conduct. Yeah, so those are our recommendations, and we will refine them further for members of parliament to read in regard to what we think the law should look like. So what to do now? I mean, the law has not yet been passed, as we have noted at the beginning. Is at the committee stage. So I think the most important thing to do is for submission of written submissions through the chambers. So the AmCham, British Chamber, NUTIP, and other chambers should coordinate and file submissions in regard to what we think the law, how the law affects the operations of all these businesses and other entities in Uganda. And then two, you can also apply to the committee to give oral evidence. So organizations with expertise on data protection, public financial management, investment, should apply and actually give oral evidence before the committees, before the bill goes into discussion. I think the Banking Association has already provided their view to the Attorney General. The Uganda Law Society is also doing, I think, some work around it. And so important that we monitor the second and third readings and see how the House debates the law. And obviously, if you're Ugandan, then you should reach out to your member of parliament and mention the concerns that you have with this law. And then finally, if the law is enacted, it would need the presidential assent. So if there are people who might reach out to the president to mention the concerns that are being raised here, please do. And then if the law is passed in its current form, again, lawyers have another remit to go to the Constitutional Court and challenge it in regard to how it affects constitutional provisions. Yeah, so we have covered, I think, the basis of one, what the law is, constitutional and other legal concerns, how it will affect businesses, and then what we recommend should be in the law, and the next steps as provided for. So thank you very much for listening to us. I think it's 10:15. We can use the rest of the time to answer questions and comments. Thank you very much.
Thank Thank you so much to the TASLAF team and to all our members that have been here. I think for me, Steve, you staying online while this, I think, in short, the law, I think one thing we've ignored as
Eve, I think you're breaking. I don't know. It could be us or it's you. You're breaking a
while
bit.
we are saying as a whole is that it's supposed to be working for the people, but in this context, I'm breaking. Can you hear me now?
That's much better. So you can repeat the earlier comments as well.
Yeah, so I was saying we want to thank you for this presentation, and I hope that people have gotten the answers they're looking for. We are going to open it up for more questions to come through. But I think one of the things that we should recognize that the government is supposed to work for the people. But in this context, literally the government is telling us that we work for them. And I don't think they've really looked at it. Burden that is being put a lot onto the minister and the authority that is being given around that. And I don't think that the government has really looked into that to understand that all these laws and all the approvals they are seeking and all the work that has to be done takes time, and unless we are going to go into a situation of where, again, creating jobs for other people in a way that the people would be the ones to work on this kind of all the work that the administration work that is going to be involved in trying to implement this law. So again, us at the chamber, our role is to really get the views from our members and everybody else and the community at large, and be able to present that as concerns to the law. And I think the recommendations you've made on where the people are, immediate actions that we need to take as organizations, as businesses, those should be really considered by members and look into it, because again, we do not know where the law is going to end and how it will be implemented at the end of the day, or if we are able to consolidate enough views as a country, as businesses, as civil society, as bankers and everybody else and investors, that this law really doesn't give value to a lot of the work. But again, we understand where they are coming from when it comes to security and protecting the sovereignty of the country. So thank you so much. I think let's take a few questions that are already in. I don't know if you had already looked at some of those questions that had come through, but there were some in the chat. If we can both, between you and me and the rest of the team, how we can be able to answer some of those. I think for me, the ones I'd kind of looked at when somebody was saying what then would be the impact of the law to the international schools that receive tuition from their students, from their employers, of their parents from abroad. So there's that question that we need to address. What would be that? Then another question came in and said, can you show us how this bill will affect the Income Tax Act, since the residents will now be considered a foreigner, and will the residents considered as a foreigner? So that could be one of the questions. And then another one, what is the penalty for a Ugandan company or NGO receives more than 400 shillings in the 12 months without getting advance written approval? So there's also that, some of the questions. I think I don't know if Steve, you're able to see the questions, or we need to review. But I think if you can answer those while we go through, and if your team can also be looking at the questions, I think Remy can answer some, and then as we go on for more.
Thanks, Eve. I think that there was a question around let me just look through them again.
Yeah.
Yeah, let's start, I think, with Godfrey, who is asking, what would the impact of this law on international schools that receive tuition of their students from employers of their parents who are abroad? Again, so because of the definition of the law seems to suggest that anyone living outside of Uganda is considered a foreigner. So if they're sending resources into Uganda in a period of 1 year of over 400 million, then they will need to register with uh, the Ministry of Internal Affairs. And the people that are sending money to also become agents. That's why we are proposing in our recommendations that personal remittances that are not concerned with political organizing or any other thing should be removed from the law. Yeah, so because it's a draft, I think, Godfrey, the answer would be you would be affected if the law is passed in its current form. But I think the window is that you can lobby to see how the remittances for persons or personal remittances are not provided for within the law. I think the other one is Mr. Patrick Gatete, who is asking can you show us how this bill will affect the Income Tax Act, since a resident will now be considered a foreigner and the profit repatriation also goes through the same procedure. Yeah, again, my personal view, not to be quoted, I think the law is shabbily drafted, very, very shabbily drafted. It does not have the concern of looking at the broader perspective of the economy. So, as you are aware, a resident under the Income Tax Act is, if you're resident in Uganda for a certain period of time, you become a resident for tax purposes. So now, if you're a resident for tax purposes for some days, it means you'll be a foreigner under this law. On other days, you're not in Uganda. So again, the drafting is really not considering other laws. If they had looked at, for instance, the law on residency under the Income Tax Act, they would not have had that clause of defining someone as a foreigner.
Yeah.
Marion, I think there's a question around threshold. Threshold is 400 million. 400 million for in a period of 12 months. I think 5 years is a comment. What is the timeline for this to be approved? Again, we've gone through the lawmaking process. So the law now is at the committee stage. It has to go for a second reading and a third reading before it is passed into law. And then there's a period of assent from the president. We cannot give definitive times. They can be between 1 month, 6 months, if they are keen on passing the law.
Yeah, Steve, there's also a question, that question of what do you mean by banking pre-authorization, and what could be the timeline? And how does the bill distinguish between the foreign influence and normal commercial funding structures, particularly for the subsidiaries of multinational companies?
Yeah, so as it is, the first question, Remy, if you could repeat the first question.
So the first question they're asking, what do we mean by banking pre-authorization, and what could be the timeline?
Okay, Remy, can you take that, please?
Yes, please. So with respect to banking pre-authorization, I think that what the clause states is that the bank should notify notify the ministry that there's certain money that has, they should always keep an open declaration. And so because of the requirement of that declaration, if the bank is in default, because it is an agent of a foreigner, in this case, a foreign entity or a Ugandan living abroad, then it will definitely be held liable. Of course, the fine, as you have seen, is 4 billion for any company that or 30 years imprisonment for individuals. So that means that you need to be able to get that pre-authorization. So a declaration has to be made by your bank, right? So you notify your bank that I will receive this amount of money on this amount of day. On this day. and then they will notify the ministry that indeed they will declare that indeed there's a deposit that's coming in, it's this big, right? But again, the limitation to that is the financial cap, which is 400 million. Of course,
Yeah.
regardless, doesn't have to be, you have to still notify, and so I think, yeah, probably that answers this question. The other question he highlighted was regarding the investment, is it?
Yeah, so he said, how does the bill distinguish between foreign influence and normal commercial funding structures, particularly
Oh,
for subsidiaries of multinational companies?
yeah, and again, I mean, it remains to be seen how this bill will pass. But as is in this form, there is no sophisticated interpretation of those particular distinctions. So whether it's all, well, as the point is that if the person is a foreigner and you're an agent of a foreigner, that's all that matters. So there's a flat line in terms of how it applies. So with respect to foreign funding flows, it's still the same thing. And so is it for other funding or financing structures. So if you did maybe an asset-backed financing for a financial institution or the like, and it was done maybe by a New York institution, it would still be the same thing.
The main point should be that when we are advocating for changes to this law, all those points should be raised. And I think within the IAVCA front, there have been proposals to make submissions to Parliament regarding how this law is going to affect their business. Yeah.
Yeah.
Because there's
Yeah.
no distinction. Yeah. There's a comment by my friend Douglas, Deogratius Wamala. I think it's asking, what do we take of the Attorney General's commentary in the papers? I think when you read the law and read the opinion, you would see the distinctions between what is provided for specifically under the law and what I think the Attorney General was discussing, which is the object. The object of the law, yes, is protect sovereignty, but the way it is being done within the law is that it is contrary to many constitutional provisions and therefore risks affecting many businesses and interests as a whole. Yeah.
Okay. So I think we've answered the questions, and some of those questions tend to seem looking at the similar. They're all looking at the same answers that have been asked. But if we don't have any more questions to be answered, or if we don't have anybody that has any really piercing question, I would like to thank you, TASLAF, for really putting up this proposal together and this presentation together. And for us as the chamber, we are going to continue working with you to be able to present our views and our concerns and recommendations to Parliament as requested. Although Parliament gave the entire country 5 days for everybody to put in their concerns as an open bid. So we want to really say thank you so much for what you've done, and then we'll continue working with you. For all our members, for anybody that if you have any concerns, people are asking Stephen if you will be able to share the presentation and of what we've just been presented. So that will be coming from you, and I would like you guys to have your closing remarks, and then we can be able to close off.
No, thank you, Ivan, and thank you all for the very active engagement. I think that as citizens of the Republic of Uganda, we owe a duty to ourselves and to posterity to have a discussion around such laws, which we think might not be in consonance with the Constitution, in consonance with the good business and general legal frameworks of the world over. So we urge everybody to continue monitoring how the law goes, but also participate in the lawmaking process through listening to the committees, making submissions, and commentaries on the law. I'm sure there's an economic analysis to be made of the law. I'm sure there are concerns around how it will affect investment. So if you're experts in that area, then you should be able to do that. I think the second thing is that there are many people who are working to do some submissions to Parliament, including the IAFCA, including the Chamber. So happy to support in that regard, and also other lawyers who are on the call support the process. We will be availing what we've presented today to the Chamber. And so Eve then can share, since she's the one with your registration details. So from us at TASLAF Advocates, we thank you for listening to us and for the participation and comments and insights. And we look forward to seeing how the law goes through. So thank you a lot.
All right, thank you so much, Stephen. We are happy to have hosted this webinar, and luckily we also had one of our coordinator from the embassy, Jacob, had joined us on the call. Jacob is the economic chief exec, is the economic officer from the U.S. embassy here. Some of our board members also joined us. Lagrima, I think I saw you as well. Thank you so much for joining us. And we are happy that we are able to have these platforms, and we ask all members that have attended today. These webinars are going to continue. It's not only about the law, but there are other webinars we usually have as the chamber that are educative, that are informative for people to be able to engage. And like Steve said, we encourage everybody, if you have the opportunity to really write about this law and the concerns that you have, please go ahead and do so. If you are within an organization that can create a voice for all, please go ahead and write about that and do those presentations. As the chamber, we are going to work together with the French chamber, the British chamber, NUTIP, and we will be able to submit those concerns as foreign chambers to Parliament, and how our businesses are going to be affected, and what are the recommendations that we are going to make in partnership with our experts from TASLAF and the rest of other experts within other chambers. So we want to thank you again for being with us today, and we will see you again next time. Follow us on all our social medias. We are there on LinkedIn, Instagram, Twitter, and all Facebook and all other social medias. We always have information there. For those of you, please, the feedback form is onto the link. The link of the feedback form is there, is being pinned up. Please go ahead and give us feedback on some of the things that you see, that understand what more we can do for you and where else we can give best service to our community. So again, thank you so much, and thank you for being with us. Have a good day.